You did not show up to court? You did not know there was a court date? The trial happened anyway. The conviction is on the record. Now a fine, or a license suspension, or a warrant. The system already made its decision. You have bail rights you have probably never been told about. This is episode 2. Most people hear the word bail and picture criminal court, serious charges, sureties in business suits, high-dollar recognizances. That association is exactly why so many provincial offenses defendants get walked over. Bail in POA proceedings does not look like criminal bail. The framework is its own. The default is more generous. And the dominant scenario is not what you would expect. This is legal education. If you have a real case, talk to a licensed professional. With that out of the way, let us begin. There is a gap in the legal landscape. Criminal code bail gets the textbooks, the case law, the news coverage. Provincial Offences Act bail gets almost nothing. That gap is not because bail rights do not exist in POA proceedings. It is because almost no one knows they do. That principle is foundational. The Crown carries the burden to justify holding someone, not the other way around. It applies in POA proceedings the same way it applies in criminal court. The Charter does not draw a line at the courtroom door based on the seriousness of the offense. Section 11 of the Charter guarantees the right not to be denied reasonable bail without just cause. The POA defendant has that right too. That is the distinction this episode is built around. If you are working on a POA matter and the word bail comes up, the first question to ask is, has there been a conviction yet? Because if the answer is yes, you are not looking at a pretrial bail hearing. You are looking at bail pending appeal under sections 110 and 150 of the POA. Two different worlds, two different statutory frameworks, two different burdens. Get the regime wrong and you fight the wrong battle. Under the criminal code, bail typically arises before trial. The accused is arrested, charged, and brings a bail hearing while proceedings work their way through the system. In POA proceedings, that sequence is often reversed. The Provincial Offences Act permits a trial to proceed in the defendant's absence. Under Section 54, if the defendant who has been served does not attend, the court may hear and determine the matter without them. The trial happens. The conviction is entered. A fine is levied. Sometimes a period of custody is imposed. The defendant learns of the conviction afterward, through a collection notice, through a license suspension, through a traffic stop where a warrant comes up on a cruiser screen. By that point, the trial is already over, and the appeal clock is running. This is why bail pending appeal, BPA, is the central bail scenario in POA practice. The defendant was never in custody before trial. They may not be in custody now, or they may have been arrested on the sentence, picked up on a warrant after a missed payment, after a license violation, after a routine check. The application framework changes depending on that custody status, and understanding the difference is essential. Two sections of the Provincial Offences Act drive the entire bail pending appeal framework: Section 110 and Section 150. Section 110 is the gateway. It does two things in a single sentence. First, it creates a custody default for appellants. If you are in custody when you appeal, you stay in custody unless and until a judge orders your release. The appeal alone does not get you out. Second, it identifies where the release authority lives. The conditions are not pulled from the criminal code. They come from Section 150 of the POA itself. That second point matters more than it looks, because Section 150 is substantially more relaxed than Criminal Code Part 16. Section 150 subsection 2 sets out the release ladder. 3 rungs. Rung A, the defendant enters into a recognizance to appear, with such conditions as are appropriate to ensure attendance in court. That is the starting point, the default landing place. No surety, no deposit, just a signed promise and conditions tied to getting back to court. Rung B, recognizance with a surety, only available where the offense is punishable by 12 months or more imprisonment, and only available where the Crown shows cause why the default rung is not enough. Rung C, recognizance plus a cash deposit or security, only for defendants not ordinarily resident in Ontario. Again, only with cause shown by the Crown. That escalation burden is critical. Section 150, subsection 3 says the justice shall not impose sureties or a deposit unless the Crown shows cause why the rung below is not enough. And Section 150, subsection 4 says the Crown must affirmatively show cause why detention is justified to ensure attendance. Detention is not the default. Detention requires the Crown to climb to the top of the ladder and prove the climb was necessary. Two procedural protections sit alongside. Section 150, subsection 5. The justice shall include reasons on the record. Section 150, subsection 7. The matter cannot be adjourned for more than 3 days without the defendant's consent. The defendants, not the Crown's, not the courts. That is the defendant's protection against being warehoused. That is the POA's bail framework. Tiered, defendant favorable, default to release. Crown bears every burden of escalation. Reasons mandatory, adjournments capped. In 2017, the Supreme Court of Canada decided RV&T, a unanimous 9-judge bench. The holding was straightforward, but it took root in every bail proceeding across this country. Courts must start at the least onerous rung of the release ladder. They can only move up when the Crown demonstrates that a less restrictive form of release will not address its legitimate concerns. Cash bail is a measure of last resort, not a starting point, not a default. Last resort. Rung 1, undertaking, no conditions. Just show up. Rung 2, undertaking with conditions. Reporting. Curfew. Geographic limits. Rung 3, recognizance, no surety. A signed promise to pay a set amount if you fail to appear. Rung 4, recognizance with a surety. Someone else vouches and goes on the hook. Rung 5, cash. Money on the table, exceptional. Crown must justify why nothing below this rung works. The POA's Section 150 sequence mirrors that ladder. Rung A, recognizance. Rung B, surety. Rung C, deposit. Section 150 is the statutory expression of the same principle the Supreme Court articulated in Antic. The Crown does not get to skip rungs. The Crown does not get to default to the top. Antic does not just inform POA bail proceedings. The POA's own framework was already built on the same architecture. The principle is statutorily reinforced and constitutionally grounded. Knowing your rights is the start. Getting bail requires building and presenting the application. A bail pending appeal application in the Ontario Court of Justice consists of a defined package. 4 documents, sometimes 3, depending on custody status. Notice of motion, bail pending appeal. The formal application that initiates the proceeding. It identifies the court, the parties, the offense dates, the conviction date, and the statutory grounds relied upon. Section 110, Section 150, and Charter Section 11. It lists the supporting documents, it states the relief sought, and it identifies the agent or legal representative serving and filing the materials. Affidavit of the defendant. This is the factual foundation of the application. The charge. The conviction circumstances, including whether the trial proceeded in the defendant's absence. The background. Age, employment, health, community ties, address. The history of attendance, and critically, the absence of any prior failure to appear convictions. The bona fide appeal, a statement that the appeal is genuine and will be diligently pursued. Financial circumstances, recognizance capacity, and primary ground compliance, undertakings to attend, to perfect the appeal, to notify of address changes, to abide by any conditions imposed. Section 150 of the POA says the justice may receive and base the decision on information considered credible or trustworthy. The affidavit is the primary vehicle. A complete, honest, focused affidavit is not optional. It is the foundation. Affidavit in support of a judge's order to produce prisoner. Required only when the defendant is currently in custody. Sworn by the legal secretary, office manager, or case manager at the representative's office. Not the defendant. It establishes that the application is filed and a hearing is scheduled. It identifies the institution where the defendant is held. It confirms the defendant's evidence is necessary at the hearing on background, antecedents, flight risk, primary ground compliance, and it confirms the application is made for no improper purpose. Judges order to produce prisoner under Section 41 of the POA. This is the order that physically gets the defendant from the institution to the courtroom. Directed to the keeper of the jail, commanding production of the prisoner at a specific courthouse, on a specific date, at a specific time, with custody arrangements while in transit, and return to the institution when attendance is no longer required. Without the Section 41 order, a defendant in custody cannot be produced. The application cannot proceed meaningfully without their evidence. Leaving this to the day before is a procedural disaster. Build it into the file at the start. The application package depends on one fact. Is the defendant in custody or not? If the defendant was never taken into custody, which is the common scenario in POA because the trial proceeded in their absence under Section 54, the application is a 3-document package. Notice of motion, defendant's affidavit, supporting documents. The defendant appears voluntarily at the hearing. No Section 41 order required. The defendant attends as a free person because the POA's own in-absence procedure was used to obtain the conviction in the first place. That is the structural irony of POA practice. The defendant who was never in custody at trial may attend the bail pending appeal hearing unrestrained because the system never restrained them. If the defendant is in custody, picked up on a sentence warrant, currently serving, the package expands. The same 3 documents plus the supporting affidavit in the Section 41 judge's order, signed by a judge and delivered to the institution before the hearing date. Same legal application. 2 procedural paths. Get the path right. R.V. Gerson-Foster, Court of Appeal for Ontario, 2019. Tafari Gerson-Foster had been on bail with his sister as surety. When she applied to be relieved, a surety warrant was issued and entered on CPIC. Before anyone executed it, Gerson-Foster came to court voluntarily with his mother as a new surety. The administrative judge canceled the original recognizance, deemed the warrant executed, issued a new bail order on consent, but nobody updated CPI. The warrant kept showing as active on the system. 5 weeks later, 2 constables were briefed that Gerson-Foster was wanted on a surety warrant. They arrested him. From the back of the cruiser, he told them the warrant was dealt with in court. The arresting officer acknowledged that CPIC can be out of date. He had personally made mistaken arrests because of it before. The other officers said they would look into it once they got to the station. They didn't look. They authorized a strip search. Cocaine fell out. He was charged. He was convicted at trial. The Court of Appeal threw the convictions out. 3 principles came out of that judgment, and they all applied directly to POA bail practice. Principle 1. Voluntary surrender to the custody of the court is sufficient. A formal arrest is not required to make a release proceeding legally effective. In the POA context, where trials routinely proceed in the defendant's absence, a defendant who was never arrested can attend a bail pending appeal hearing as a voluntary participant. The Section 41 order is not needed in that scenario because the defendant is not in custody. The bail proceeding still has full legal force. Principle 2. Once a detainee asserts a legal basis for release, the obligation to investigate becomes active, not passive, not deferred. The Crown in a BPA proceeding cannot simply object without engaging. Once the defendant has filed an affidavit with the facts on the record, the Crown must respond on the substance. The justice must engage. Reasons must be given. Principle 3. The right not to be arbitrarily detained applies every time a defendant is held. POA defendants in custody pending appeal have the same charter protection as any other detainee. The Crown must justify custody. If it cannot, detention is arbitrary and constitutionally impermissible. Gerson-Foster is not a bail case on its facts. It is a charter case about a stale CPIC entry, but its principles are the architectural underpinning of every POA bail pending appeal application. Antic was a criminal code bail review. A bail review judge had insisted on a $100,000 cash bail despite the defendant offering 3 sureties and a monetary pledge. The Supreme Court, unanimously, 9 judges, said that was wrong at every level of the analysis. The Ladder principle. The Crown bears the burden at each step up. Cash bail is not interchangeable with a pledge. A recognizance carries the same financial consequence and the same coercive incentive to appear. A judge who insists on cash because they believe cash is more coercive than a pledge is simply wrong and operating on an assumption that has no support in law or evidence. The court also said something blunt. A recognizance amount that the accused cannot meet is effectively a detention order. A positive obligation rests on the judge to inquire into ability to pay. Cash bail set at a level the accused cannot raise is not a release. It is a sentence by another name. 16 years before Oland, Farinacci established the constitutional foundation of bail pending appeal in Ontario. A 5-judge panel, unanimous, written by Justice Arbor. The question, in a post-conviction context, does the public interest criterion for bail pending appeal survive a charter vagueness challenge? The court held it does. The presumption of innocence governs before and during trial. After conviction, the presumption is spent. The conviction is a legal fact. What remains is a balancing exercise between two competing interests. Enforceability, the principle that judgments take effect immediately, and reviewability, the principle that a statutory right of appeal must not be rendered meaningless by the passage of time. Farinacci is the foundation Oland builds on 24 years later. The framework is enforceability against reviewability. Both matter. Both are weighed. The balance shifts with the facts. R.V. Oland, 2017. Dennis Oland had been convicted of second-degree murder. A single appeal judge had denied his bail pending appeal. By the time the Supreme Court heard the matter, the New Brunswick Court of Appeal had already ordered a new trial. The bail issue was moot, but the Supreme Court heard the case anyway. Because the jurisprudence was a mess, and the issue evaded appellate review by its nature. The 3-part test under Section 679. The appeal is not frivolous. The applicant will surrender. Detention is not necessary in the public interest. The court confirmed Farinacci remains good law and gave the public interest analysis a structure it badly needed. On the enforceability side, the seriousness of the offense. The trial judge's sentencing findings are the starting point. Residual public safety concerns feed in. On the reviewability side, the strength of the grounds of appeal. The court warned against grading schemes. Phrases like moderate prospect of success or realistic prospect of success invite inconsistency. The task is qualitative. RVHK, 2022. A 67-year-old Canadian citizen with no criminal record was sentenced to 10 months imprisonment. He applied to Justice Gillies for release pending appeal. The Crown opposed. They said the appeal had no merit. They said detention was necessary in the public interest. Justice Gillies disagreed at every step. The not frivolous threshold was easily met, especially on the sentence appeal, where evidence of extraordinary hardship may not have been considered. But the centerpiece of the judgment was the mootness math. On a 10-month sentence, parole eligibility at roughly 3.5 months, earned remission at roughly 6.5 months. The time between application and the realistic appeal hearing exceeded that window. If bail were denied, HK would serve the custodial portion of his sentence before the appeal was ever heard. That makes the sentence appeal moot. And mootness, Justice Gillies held, is not a technicality, it is a substantive injustice. An appeal that is rendered meaningless by the passage of time is not justice delayed, it is justice eliminated. The risk of mootness alone weighed heavily in favor of release. That is the lesson for POA practice. POA sentences are frequently shorter than the 10 months in HK, which means the mootness risk in POA bail pending appeal is more immediate. Often near certain. Run the numbers on every application. Calculate the parole eligibility date, 1/3 of sentence. Calculate the earned remission date, 2/3. Compare against the earliest realistic appeal hearing date. If the defendant will likely serve the sentence before the appeal is decided, that fact goes in the affidavit. It goes in the oral submissions. It may be the single most powerful argument you make. 8 traps appear over and over in POA bail pending appeal practice. Trap 1. treating the application like a pretrial bail hearing. The governing framework is the POA's own, Sections 110 and 150, not the criminal code show cause regime. Know which regime applies. Trap 2. Forgetting the Section 41 order. Without it, the defendant cannot be produced. Build it into the file from day one. Trap 3. Allowing sureties to be required without the Crown showing cause under Section 150. The Crown does not get sureties by default. Demand the showing. Trap 4. Accepting a detention order without the Crown affirmatively establishing cause under Section 150. Silence is not cause. Vague assertion is not cause. Hold the line. Trap 5. Ignoring Section 150. The matter cannot be adjourned for more than 3 days without the defendant's consent. The defendants, not the Crown's, not the court's. Trap 6. Thinking that because the trial happened without the defendant under Section 54, a bail pending appeal application is foreclosed. It is not. The application is about the appeal, not about trial attendance. Bona fide appeal is the operative question. Trap 7. Confusing who carries the burden. The Crown justifies detention. You do not prove you deserve freedom. The defendant's affidavit establishes the foundation. The Crown must rebut. Trap 8. Forgetting the mootness math from HK and Oland. Run the parole and remission numbers. Put them in the affidavit. Before you file, confirm the notice of appeal is in. Confirm custody status. If in custody, identify the institution and arrange the Section 41 deponent. Collect the charging document. Order the trial transcript. Gather supporting documents. Employment letter, bank statement, driving record if relevant. The package. Notice of motion with statutory references. Defendant's affidavit with no fail to appear, bona fide appeal, primary ground compliance, financial circumstances. If in custody, the S-41 affidavit in the S-41 order signed before the hearing date. Supporting documents assembled. Application served on the prosecutor and clerk. At the hearing, what position is the Crown taking? Consent, show cause, detention. If sureties are being sought, is the charge punishable by 12 months or more? Has cause been shown? If a deposit is being sought, is the defendant a non-resident? If detention is being sought, what specifically is the Crown's evidence? Are the proposed conditions tied to attendance only? Is the recognizance amount within demonstrated means? And Section 150, has the justice given reasons on the record? The POA bail framework is, arguably, the cleanest bail regime in Ontario practice. Tiered, defendant favorable, default to release, Crown bears every burden of escalation, reasons mandatory, adjournments capped at 3 days. Most defendants will never hear about any of it, which is precisely why this episode exists. The full handout for this episode is on the You Defend You website. Statute references for Sections 41, 110, and 150. The full case authorities, Gerson-Foster, Antic, Farinacci, Oland, HK. The 4-document application package. The traps, the checklist, printable, free. Use it against your own paperwork. Use it against the Crown's. The math from HK, the parole eligibility math, the remission math is right there. This was Episode 2, POA Bail. Episode 1 covered the laying of charges. Episode 3 will cover trial procedure under the POA, what actually happens in the courtroom, and what the defendant's rights are at each